What are defective drugs and how do they affect Florida patients? When you walk into a pharmacy and pick up your prescription, you trust that the medication inside the bottle has been thoroughly tested, properly manufactured, and will help rather than harm you. Unfortunately, that trust is sometimes misplaced. As a personal injury attorney who has represented Florida families for almost 35 years, I've seen firsthand how defective drugs can devastate lives. I want you to understand exactly what constitutes a defective drug and what your rights are if you've been harmed. I'm attorney Doug Burnetti, and I've represented thousands of people throughout the United States. And let's start with learning exactly what a defective drug is and isn't. A defective drug isn't just a medication that doesn't work as expected. Under Florida law, we typically see three categories of defective drugs. First, there are manufacturing defects, where something goes wrong during the production process. Think of the Digitech recall in 2008, where some pills contain double the approved amount of active ingredient due to manufacturing errors. Patients who receive those double-strength tablets face serious risks of digitalis toxicity, including cardiac instability and even death. The second category involves design defects, where the drug itself is inherently dangerous even when manufactured correctly. These cases are more complex because we have to prove that the risks outweigh the benefits for the intended patient population. The third category, and perhaps the most common in my practice, involves failure to warn. This is where pharmaceutical companies know about serious side effects but fail to adequately inform doctors and patients about those risks. How pharmaceutical companies fail their legal duty. Under Florida's product liability laws, pharmaceutical companies have a legal duty to warn patients and healthcare providers about known risks associated with their medications. This duty extends beyond just listing side effects on a packaged insert. Companies must actively monitor their drugs after they reach the market, conduct post-market surveillance studies, and update their warnings when new safety information becomes available. I've handled cases where companies discovered serious safety signals in their own internal studies, but delayed updating their warning labels for months or even years. In one case involving a popular blood thinner, internal company documents showed they knew about an increased bleeding risk in elderly patients, but they didn't update their warnings until after the FDA intervened. During that delay, hundreds of patients suffered preventable bleeding complications. The legal standard in Florida follows what's called the Learned Intermediary Doctrine, established in cases like Doe versus Miles Laboratories. This means pharmaceutical companies typically fulfill their duty to warn by providing adequate information to prescribing physicians, who then serve as learned intermediaries between the company and the patient. However, this doctrine has exceptions, particularly when companies engage in direct-to-consumer advertising or when they fail to provide adequate warnings even to physicians. Common types of defective drug injuries in Florida. The injuries I see from defective drugs range from temporary setbacks to permanent disabilities and wrongful death. Blood clots represent one of the most serious categories. I've represented women who develop deep vein thrombosis and pulmonary embolisms from birth control pills containing drospirenone like Yaz and Yasmin. These aren't rare side effects we're talking about. Studies have shown these newer birth control formulations carry significantly higher clotting risk than older formulations, yet many patients were never informed of this increased danger. Cardiovascular injuries from another major category. Testosterone replacement therapies like androgel gained massive popularity in the early 2000s, with prescriptions increasing fivefold between 2000 and 2011. However, studies later revealed that men over 65 using these products faced twice the risk of heart attack, while younger men with existing heart disease saw their risk nearly triple. What made this particularly troubling was that many prescriptions were written for men who hadn't even been properly tested for low testosterone levels. Birth defects represent perhaps the most heartbreaking category of defective drug injuries. SSRI antidepressants like Zoloft and Lexapro, when taken during pregnancy, have been linked to serious congenital heart defects. The FDA issued warnings about these risks as early as 2005 based on studies showing increased rates of septal heart defects in babies whose mothers took these medications during their first trimester. Yet many women continued to receive these prescriptions without adequate counseling about the potential risks to their unborn children. Kidney damage is another serious consequence I've seen, particularly with drugs like Elmron, used to treat bladder pain syndrome. Patients developed a condition called pigmentary maculopathy, which can cause permanent vision problems and even blindness. Many patients took this medication for years without knowing about the vision risk because the manufacturer failed to adequately warn about the serious side effects. The FDA approval process and its limitations. Many people assume that FDA approval means a drug is completely safe, but that's not how the system works. The FDA approval process is designed to determine whether a drug's benefits outweigh its known risks for particular medical conditions. However, this process has significant limitations that can leave patients vulnerable. Clinical trials required for FDA approval typically involve relatively small numbers of patients followed for relatively short periods. Rare side effects that might affect 1 in 10,000 patients or side effects that take years to develop often don't show up until after a drug reaches the market and is used by millions of people. This is why post-market surveillance is so critical and why companies have an ongoing duty to monitor their products and update their warnings. The FDA also operates under significant resource constraints. The agency relies heavily on data provided by pharmaceutical companies themselves, and the FDA doesn't have the resources to independently verify every study. This creates an inherent conflict of interest that sometimes allows dangerous drugs to remain on the market longer than they should. I've seen cases where companies submitted selective data to the FDA, highlighting positive results while downplaying negative findings. In some instances, companies have conducted multiple studies but only submitted the ones that showed favorable results, a practice known as publication bias. When the full picture eventually emerges, often through litigation discovery, we sometimes find that the risk-benefit analysis would have been very different if all the data had been considered. Florida statute of limitations for defective drug cases. If you believe you've been harmed by a defective drug, time is not on your side. Florida has strict statutes of limitations that can bar your claim if you wait too long to file. Under Florida Statute 95.11, you generally have 4 years from the date you knew or should have known that your injury was caused by the defective drug. There may be an argument now that it's only 2 years. However, there's also an overall statute of repose that can cut off your rights after a certain period regardless of when you discovered the connection. The discovery rule can be particularly important in defective drug cases because some injuries don't manifest immediately. For example, if you develop kidney problems from a medication you took 5 years ago, your 4-year limitation period might not start running until you discovered that the medication caused your kidney problems. However, proving when you should have reasonably discovered this connection can be complex and fact-specific. In cases involving wrongful death, under Florida Statute 768.19, generally provides a 2-year statute of limitations period from the date of death. However, if the death was caused by a defective drug and the connection wasn't immediately apparent, the discovery rule might extend the period, maybe. These timing issues can be complicated, which is why it's crucial to consult with an attorney as soon as you suspect connection between a medication and an injury. Building a strong defective drug case. Winning a defective drug case requires more than just showing that you took a medication and suffered an injury. We need to establish what lawyers call causation, meaning we must prove that the drug actually caused the specific injury. This often requires extensive medical evidence and expert testimony. We typically start by obtaining all your medical records, not just those related to the injury, but your complete medical history. We need to understand your health status before you started taking the medication and document how your condition changed after you began treatment. We also review the prescribing information, FDA communications, and any warnings that were provided to your doctor. Expert witnesses play a crucial role in these cases. We work with physicians who specialize in the relevant medical areas, pharmacologists who understand how drugs work in the body, and epidemiologists who can analyze population-level data about drug risks. These experts help us demonstrate that your injury was more likely caused by the medication than by other potential factors. We also conduct extensive discovery into the pharmaceutical company's internal documents. Through the litigation process, we can obtain company emails, study reports, regulatory submissions, and other material that might not be publicly available. Sometimes these documents reveal that companies knew about risks much earlier than they publicly acknowledged, or they had data showing their drugs were more dangerous than they claimed. What compensation might be available? If you've been harmed by a defective drug, Florida law allows you to seek compensation for both economic and non-economic damages. Economic damages include your medical bills, both past and future, lost wages, and any other out-of-pocket expenses relative to your injury. If your injury has affected your ability to work, you might also recover compensation for lost earning capacity. Non-economic damages compensate you for pain and suffering, mental anguish, loss of capacity for the enjoyment of life, inconvenience, those types of non-economic injuries. If you've developed a permanent disability or disfigurement, these damages can be substantial. Florida law also recognizes loss of consortium claims, which compensate your spouse for the impact your injury had on them. In cases involving particularly egregious conduct by pharmaceutical companies, Florida courts may allow for punitive damages under Florida Statute 768.73. These damages are designed to punish the defendant and deter similar conduct in the future. However, punitive damages are only available when we can show that the company's conduct showed a conscious disregard and/or recklessness for the safety of others. The amount of compensation varies significantly depending on the severity of your injury, your age, your earning capacity, and many other factors. I've handled cases where settlements range from hundreds of thousands of dollars for serious but temporary injuries to multi-million-dollar recoveries for permanent disabilities or wrongful death. Why you need experienced legal representation. Pharmaceutical companies don't just roll over when faced with defective drug lawsuits. These are billion-dollar corporations with teams of lawyers whose job it is to minimize their liability. They have resources that individual patients simply can't match, and they're not afraid to use them. These companies often employ several defense strategies. They might argue that your injury was caused by your underlying medical condition rather than their drug. They might claim that the warnings they provided were adequate, even if those warnings were buried in fine print or written in technical language that patients couldn't understand anyway. They might also argue that your doctor should have known about the risks and chosen a different medication. Having an attorney who understands these tactics and knows how to counter them is essential. We know how to work with medical experts who can establish causation, how to interpret complex scientific studies, and how to navigate the regulatory landscape that governs pharmaceutical litigation. We also understand how to value these cases appropriately and negotiate with insurance companies and corporate defense teams. Taking the first steps. If you believe you've been harmed by a defective drug, the most important thing you can do right now is preserve the evidence. Keep the medication bottle, even if it's empty. Maintain all your medical records and continue to document any ongoing symptoms or treatments. Don't stop taking prescribed medications without consulting your doctor, as this could be dangerous and might also affect your legal case. You should also be aware that defective drug cases often involve multiple plaintiffs who are harmed by the same medication. In some instances, these cases are consolidated into what's called multi-district litigation, or MDL, which can provide advantages in terms of sharing discovery costs and developing the science behind your case. The consultation process with our firm is straightforward. We'll review your medical records, research the specific medication involved, and give you an honest assessment of whether you have a viable case. We handle these cases on a contingency fee basis, which means you don't pay attorney's fees unless we recover compensation for you. Now, winning a defective drug case is just one part of protecting yourself and your family from pharmaceutical injuries. What many people don't realize is that if you've been in a car accident while taking medications that might have impaired your driving or affected your reaction time, this can significantly impact your personal injury case. Insurance companies will look for any reason to reduce your settlement, and they'll absolutely use your medical history and your medications against you if they can. That's why my next video covers the 5 critical tips to maximize your car accident settlement right here in Florida. I'll show you exactly how to protect yourself from insurance company tactics, what documentation you should absolutely preserve, and the specific Florida laws that can either help or hurt your case depending on how you handle the situation. If you've been in an accident or if you're taking medications that could affect your driving, this information could be worth tens of thousands of dollars to your case. See you over there.